Good evening, I am Ahmad Dinobawe. Now tonight we'll be taking a look at the Presidential Election Petition Tribunal judgment, the implications and what it means for future cases and for the people of Nigeria. We'll be taking a look at each provision and each ruling and judgment on key cases such as the 25% requirements for the FCT, such as the issue of electronic vote transmission, and so on and so forth. I have with me tonight Mr. Genesis Francis is a legal practitioner. He joins me now to do justice to the matter. All right, Mr. Genesis Francis, good evening. It's good to have you.
Good evening. How are you?
I'm good. Like everyone has been, we've all been following the presidential election petition tribunal judgment. I'd like to get your thoughts as to so far, how things have gone. Some persons say they expected everything that is happening. Others still kind of have arguments and say, this is how this should have gone. I don't know why it went this way and so on and so forth. But I'd just like to get your thoughts generally.
Well, concerning judgments of courts in Nigeria, my default outlook is never to be too expectant of one extreme or the other. It is safe for my sanity to carry a liberal approach, an open mind, while hearing the ratio decidendi upon which the court is making its judgment, because every judgment is a product of a ratio, a reasoning, a principle of law. So my lords will always adduce reasons why they take a position or another. So if you come before the courts as a Nigerian and you're already set in your views that you expect it to be this way, you may just be struck by a great degree of disappointment. So a liberal mind before the tribunal is a healthy outlook, because you get to hear why they take a position. Of course, the fact that you listen to their position does not mean that you are bound by that decision. You could have a contrary view or say you disagree. That's why you have room to appeal. But going in, just carry an open mind, hear what they have to say, then you take your view and state how you feel about what their position is on a matter.
Right, that's fair enough.
Yes.
A lot of lawyers, even regular Nigerians, I don't know if that's a funny thing to say. Lawyers are also regular people. But anyway, a lot of people were looking forward to clear resolutions for certain issues that were brought up. But let's start with the APM case, which had to do with, to an extent, the vice presidential candidates, is it double domination or thereabouts? And the court ruled on it and said it's a pre-election matter and so on. What do you make of that situation? Okay,
so I was privileged to listen to that part of the judgment, and they gave their reasoning to say that the candidate for the election who won the primaries was Bola Ahmed Tinubu, not Shettima, and he was the one on the ballot. Shettima is his running mate. Whatever intricacies went wrong as to whether he was the senatorial candidate for his party under the Borno Central Senatorial District, and how that he had to leave that to come pick up the running mate slot for Tinubu, to the extent it was not contested by people who were interested within the party. It is too late in the day. Of course, they gave their reasoning. Any contention you have for those inter-party affairs should not come to this tribunal. There are matters you should have dealt with before the High Court, the Federal High Court. As at the pre-election matters, these are pre-election matters. Pre-election matters go to the High Court. So having not, they went to the High Court. Why? So the tribunal is saying, why are you bringing this to us? And more so, the law is clear. Party matters are party affairs. You don't expect that an intra-party matter is attacked upon by somebody who is not within the party. What is your interest in a party affair? The people within the party should be the ones saying, no, this is wrong. He already has tickets, Or maybe in worst case scenario, INEC should be the one challenging. Did he satisfy constitutional requirements for jumping from senatorial ballot to vice presidential ballot? Once all of those questions are tidy within those extremes, it doesn't lie in the place of petitioners, in this case, the Labour Party or the PDP, coming to the tribunal to say, disqualify Ahmed Bola Tinubu on the basis of his running mates. It's incoherent in my view. Yes.
All right. But the argument there that isn't a precedent being set here where if no party member has issue with a problem, then it doesn't matter how they got the nomination or whatever rules they break. And then if you think about it really, it is in the interest of a party to field maybe a strong candidate, so to speak. So if party members are not inclined to take up the case, it means that it doesn't matter how someone emerged, they just get to have that free reign. And people say, couldn't this be abused in one way or another? And then I'll cite an example. If I don't know, you can help us out here with what the difference really is. In Bayelsa, the current governor, Doye Diri, he became governor because of an issue that I believe the actual winner of the election, who was in the APC, had with his deputy. That was how I believe he wasn't qualified or nomination or thereabouts. And because of the deputy of that governor, or governor to be at the time, he was sacked by the courts. And then Doye Diri became governor. What really has changed?
Okay, so I'll go back to what I said earlier. The ground rules for challenging pre-election matters, starting with Tinubu and Shetima, the ticket, has to do with what the party accepts as okay and who is challenging the process engaged. So every party has its constitution, and some of those constitutions will state for an election. The position of a vice president or a deputy governor is not an electable, is an appointment. Whoever wins the ballot now appoints another to join him on that ballot. And some parties even take the extreme to say, we don't even want to do elections. We make a consensus. We give a consensus candidate. So there's no election for primaries for the person to become their flag bearer. It happens. So what do you say if there was no election and they just agreed by consensus that A is our candidate? For the Bayelsa matter, like I said, every case have its peculiar set of facts. So for the Bayelsa case, who went to court? Was it another party? It was an intra-party affair. And they went to a court that has jurisdiction to hear that matter. That's why it was even heard. This election petition tribunal is saying this matter is not even within our scope. It's a pre-election matter. You should have gone to the Federal High Court, where your grievances in this regard would have been heard. But as a matter of, for avoidance of doubt, this matter has no business to be coming here. Because first of all, the law is clear as to who can sue for an intra-party affair. If you are not in that party, on what locus are you even suing over this matter? Whether it is before the Federal High Court or before the Tribunal. So I think that's just the clarification. The two cases are not with similar facts. That's what I can say on that.
Yeah, that's fair enough. Now let's move into, that was the APM case, the first case that received judgment, if that's the word to explain it. Then moved on to the Labour Party. There are a couple of issues that have already been decided upon, but let's start with the issue of 25% in the FCT. The court sort of agreed with the argument of the APC and Asiwaju Bola Ahmed Tinubu that Abuja has no special status that it bestows upon citizens, and hence their vote shouldn't count more than others. And the word it uses that it is irrelevant. That is the word. It is irrelevant that President Bola Ahmed Tinubu did not meet the 25% in Abuja. What do you make of that dynamic?
So, I think it's high time we go back to legal drafting. In drafting, The first concern you have is rules of interpretation. So the word, what has caused all of this drama is that word "and." 2/3 of all the states and the FCT, and that's section 134 of the Constitution. So do you interpret the word "and" to be conjunctive or disjunctive? That has been the whole saga over this matter, and it's a matter of convenience of interpretation, because there was no proviso to clarify by the makers of the Constitution at the time it was the Constitution was amended to have that rule. All of these weaknesses were allowed, so nobody really knows the actual intendment of the drafters of the Constitution. Did they intend the word "and" to be conjunctive, meaning 36 plus 1, making it 37, so you need 2/3 of 37 states, or did they intend it to be 36 and the FCT standing alone, meaning if you have 2/3 from 36, then you also need 2/3 from FCT having secured this 36? These matters ordinarily shouldn't be causing all of this tension if provisos or clarifications were made. So that brings us to the need for maybe a constitutional amendment, but as it stands, it lies in the bosom of the justices, the judex, to interpret. That's the work of the judiciary, is to interpret laws. They have interpreted it in the way and manner they deem appropriate. Whether I like it or I don't like it is a matter for another day. My own recommendation will be, moving forward, the makers of the law should be clear. If you intended, some people have proffered arguments to say that FCT actually carries a status a little unique than other states. It is the seat of power. It is the place that carries all the lawmakers, the president. People who are here are people who are a reflection of what Nigeria is. Almost every tribe has representation in the FCT. So it's a unique location that deserves a unique attribute. But the real question is, when the people who were couching that provision, section 134, were couching that provision and used the word "and" the FCT, did they intend it to have that unique feature? We don't have that clarification. So I think it's a call for further constitutional amendment, so it won't be out of place moving forward that the National Assembly make it explicitly clear that this is what we intend by this, by either making a proviso or recouching that entire section to make it explicitly clear what the position is, whether it's supposed to get a special status or it's supposed to be treated as one of the states. But as it is now, the Court of Appeal has taken a position, or the panel rather, the election petition panel at the Court of Appeal has taken a position. Whether or not the Supreme Court will take the same position on appeal, because these matters will go on appeal, is another question that we're all waiting to see unfold.
Right, that's it's interesting. I have a question. This is more a personal question of curiosity about the law. You spoke about constitutional amendment. I know that lawyers often cite, even judges. I've been privy to witness judgments being read out, and sometimes while reading their judgments, they reference other cases. They say so versus so, and then they if this case is rounded off, versus, hypothetically speaking, it gets to the Supreme Court agrees 25% is irrelevant, and so on, is there still need for amendment, or because the Supreme Court has answered that question, henceforth, there is no need, there's no more ambiguity? It now means that everybody takes it that 36 plus FCT means, 37, so to speak.
So it's good you're asking the question. So if the makers of the law feel that that position as taken by the petition tribunal, which will go to Supreme Court, if Supreme Court takes this same position that "and" is conjunctive, meaning FCT is to be treated as a state and no more, then if that is what the lawmakers want it to be interpreted as, it is safe for them not to even bother going into a constitutional amendment. Excuse me. So with that, the stand of the Supreme Court becomes final on that point for the reasons and purposes of interpretation. So that proviso I was talking about, this Supreme Court judgment will now become an enabler or an interpretation of what you need to take as a matter of stance when you're reading the provision of the Constitution. However, if the lawmakers feel that no, this is not a true reflection of how we feel about this provision of the law, nothing stops them from going ahead to say we would amend the provision of that Constitution to carry the actual meaning we intended to have, which is not exactly the same with what the Supreme Court had given in her judgment. And once they do that amendment, whatever the Supreme Court may have said on that law becomes academic. It is the amended law that now becomes operational. Of course, it will be tested, because when other matters come and that provision is affected, the Supreme Court will be asked again to now give its interpretation of the new amendment. Of course, if the new amendment now clearly defines what the interpretation of the "and" or whatever phrase they would use or word they would use, then the Supreme Court cannot be giving the former interpretation to this new amendment. They'll have to look at it again with the new eye that the couching of that law has, and give it their understanding, because that's the entire basics of this. What is your understanding as an interpreter of the law of this provision of the law?
Yeah, that's very interesting. Maybe in layman's terms, I would say the amended law kind of trumps, whatever may have happened in the courts.
It does.
So moving forward, another issue was transmission of results electronically. It was a major bone of contention. I believe a lot of Nigerians saw it as a route to keeping INEC in check, so to speak, so that whatever INEC is doing, we have our own sort of citizen office, so to speak, where we monitor transmissions, because that's where citizens can get it without having to go through any sort of process. But the court now has said that INEC was never bound by that. Yes, INEC on different occasions released statements, made press briefings where they said electronic transmission is there to stay and it would not go anywhere. But the court is saying that it is not contained in the Electoral Act, so it doesn't matter. Was this also something foreseen?
So, at the time the Electoral Act was amended and the use of electronic reader, the electronic reading devices was incorporated in the Electoral Act, we were all excited and we were like, okay, our electoral processes will take a leap for it. Now, the same Electoral Act as amended 2022, of course, any law, if it must find expression amongst a people, must allow the agency in charge or the commission in charge of implementing the provisions of that law some rooms to make rules or guidelines for operations. Because if you have to keep rules or guidelines are meant to move with the trends and times. So you could have guidelines on each and every election year for Electoral Act, but you cannot be having the act amended on each and every election year. It will be too cumbersome and stressful for the legislators. So the Electoral Act, recognizing the need for those modifications here and there on the guideline, made the amendment needed in the 2022 Electoral Act and allowed for room for the commission, the INEC, to make guidelines for its operations or conduction of an election. So INEC took advantage of that and made the guidelines 2023 for the purposes of these elections. And it was in the guidelines that they talked about IREV, electronic transmission of results. The Electoral Act, as amended 2022, did not say anything about electronic transmission of results. It is part of the innovation by INEC to enable transparency and efficiency of their delivery of their mandates as enabled by the law. And we were all excited about it. We were all happy. And we were like, if INEC can do this, then Nigeria is heading somewhere. INEC did not do what they said they would do. So the real question which the Petition Tribunal attended to today is the refusal of INEC to follow what its guideline stated, is it a basis or a ground for challenging the elections? So section 134, subsection 2 of the amended Electoral Act says grounds for challenging an election must be grounds of a violation of the law, the Electoral Act itself. You cannot now, having stated that clearly, you can't now come and be challenging an election only because a guideline was violated. That's what the Election Petition Tribunal was clarifying today. So, and the law is the law. What is not in the law, we cannot impute in the law. Moving forward, we can now probably push. Some years back, even the use of card reader was not in the Electoral Act, but now it is in the Electoral Act. Moving forward, we can now push for this electronic transmission to transit from being a guideline to be part of the Electoral Act. If that happens, then INEC cannot now refuse overnight.
So it's a better hold them accountable.
Yes. So, but these are innovations. The law is progressive. We are hoping that moving forward, some of these matters can transit from just being guidelines that INEC can excite us about and wake up and change their mind into being part of the substantive law where they are bound to follow, because we know that it will breed for transparency and credibility.
Yeah, that's fair enough. It's an issue that a lot of people argue over, and interestingly, these things are just being resolved, and I think people expected a little bit more to the resolution, but in terms of how easy it seems, as though, this was obvious, why didn't you notice it the court? But let's move on now to the issue of the alleged drug trafficking. The Labour Party said President Tinubu had to forfeit about $460,000, and that it was over drug-related offences, and hence he was not qualified to be president. But the court ruled that it was a civil rule, it wasn't a criminal rule, and that there was no evidence that he was tried or arraigned and prosecuted, so to speak, and hence it was a civil matter. And because it's a civil matter, it doesn't count. What do you make of that?
So, it is easy for us to sit and analyze. But I've actually contemplated if for any reason it is my brother who for some strange reasons is found in that position, rightly or wrongly, and judgment was given, he forfeited money, and he now comes back to seek for an opportunity to serve his people, would I be fair to say that he should be disqualified only because his money was seized? I am not, and like you said, these matters were matters of over 10 years ago. There's a time within which you should allow people to take some fresh air from their past. Rightly or wrongly, we still do not know what came about the true forfeiture. What were the details, the back scene drama that played out? Did they catch him in drug trafficking? I know United States of America, if they know you to be a drug trafficker, you don't go scot-free. They would hunt you. They will even go to you wherever you are, even if it's outside the US, and bring you back and try you criminally. So whatever played out, however it played out, if there was no trial, which we don't have as we stand, and this number of years have passed, and we don't have any record anywhere that says he was actually a drug lord, all of these views and opinions of people. And I don't think we should be holding so dearly to that. No, Jesus would say, he who has no sin, let him cast the first stone. So my view on this matter of drug-related offense is, I think we should just let it. Let's look at the real issues on ground. Issue of competence, issue of votes cast, issue of the will of the Nigerian people, issue of whether his character is tainted because of all of those judgments, are not the core for this election. The core is, what did the people want? And how did the people express what they wanted? Very important.
All right. The Labour Party was actually said to not have adequately proved that it scored the most votes, because that was the allegation. They got the most votes, but the APC allegedly cannibalized their votes, took it for themselves. They said the party did not prove that. They did not give what their original number was if their votes were cannibalized, and that they just couldn't get enough specific polling units where this theft occurred. What do you make of that? Is there, do you think there's a function of perhaps quote-unquote structure, like they say, where other parties are able to have polling unit agents pretty much everywhere? Do you think that was what might have held the court back here in terms of the Labour Party, which did not have as much on ground? Is it those formiciates and so on that what will I say, that are paramount, or was it a case of INEC supplying the certified true copies, as they call them, to the Labour Party? Who would you say was really at fault there?
So elections have come and gone. You, the petitioner, is alleging that there were irregularities. You, the petitioner, before the election was concluded, is expected to have your agents nationwide. Your agents ordinarily, from the polling units, as results are being collated and announced, are supposed to be given a form, one of the forms, a duplicate of the form at the polling unit. When they go to the Ward Collation Center and it's collated at that level, they get a duplicate. Local Government Collation Center, they get a duplicate. State Collation Center, they get a duplicate. And of course, eventually at the National Collation Center. So the whole story of not being able to verify, or maybe somebody collected or snatched, these are matters in this era of technology. They allow for electronic proof. If you have such proof that so number of polling units were wrongly represented because ballot papers were snatched, your officers at the polling unit who had their duplicate, assuming it was at the local government level that the forgery or the variation happened, what proof do you have to show from your own agent's duplicate of the word local polling unit collations that make up that local government, that word that was altered, to debunk what they have now presented as an altered result? So that's how you prove and you challenge results of the other side.
So basically, parties that don't have that widespread structure, it will be hard for them to make a case.
Exactly. But I don't even think there was such a party among these three contenders, the Labour Party, the PDP, and the APC.
You believe the Labour was able to have that much?
From my observation, they were able to spread. I wouldn't know the degree of spread they had in all polling units of Nigeria, but they had substantial spread to be able to make a good case for themselves. Whether the persons who stood for them at those level were really credible to help them make sure that they have their votes were properly protected is another matter. And you know the general story about this election, you do not expect to have 100% perfect election anywhere in the world. In Nigeria, the legal threshold for a viable or a credible election is substantial compliance. And what does substantial compliance mean? It means that the person who is challenging the election, the petitioner, is able to show before the court. Substantial non-compliance means the petitioner is able to show to the court that irregularities have played out and affected votes. And if you add up the votes affected by these irregularities, it outnumbers the margin between the candidate that won and the petitioner. Once that margin of irregularity in number of votes is more than the margin between winner and petitioner, the person who lost, who is now complaining, then there is substantial compliance. But if your complaint about non-compliance does not make up to the margin, we don't have the resources to be making those arguments and asking you to go back and get a 100% perfect result. It doesn't work.
Right, I believe that's one of the things that Peter Obi, the Labour Party candidate, is being told. We'll get to find out more. Well, it's been great having you to sort of break down what I might call the first part of this. Hopefully, we'll get to meet another time and delve into the second part. Thank you so much for coming.
Thank you, sir.
Mr. Francis.
Thank you.